What used to be referred to as Section 43 payments under the Workers' Rehabilitation and Compensation Act is now referred to as Section 58 payments under the Return to Work Act 2014. Those payments are assessed in much the same manner as they were under the Workers' Rehabilitation and Compensation Act in terms of an assessment by an accredited assessor who considers your level of permanent impairment in accordance with the AMA guides and produces a medical report. There is a slight difference in that only one assessment is allowed now and a compensating authority is required to agree with the medical opinion that is obtained. There can then be a dispute in relation to whether or not that level of impairment is correct or not, but at least there shouldn't be too much shopping around for various doctors and buying opinions. In terms of the amount of money that a worker may be awarded for their permanent impairment, again, that hasn't changed too much under the new system from the old system. Again, based on a 5% whole person impairment, which is the minimum threshold that a worker needs to receive, there is compensation payable, and that increases exponentially depending on the level of whole person impairment that you're assessed as having. There is also a new lump sum that has been introduced under the Return to Work Act 2014. That is a lump sum that is payable to any worker who has a whole person impairment of between 5% and 29%. That is referred to as a payment for economic loss, and it is intended by the government to compensate workers for them having their weekly payments and their medical expenses cut off after their various cut-off dates. The further compensation that might be payable is calculated having regard to a formula depending on the year of injury, the nature of the work and the working hours that the worker did prior to sustaining the injury, and according to the level of whole person impairment that they have been left with. So it is vitally important for workers who've sustained injuries after the 1st of July 2015 to make sure that they get advice to also claim this further lump sum that they are entitled to. Under the Section 56 payments, which are the new lump sums that have been introduced, they only apply to workers who sustain injuries from the 1st of July 2015. That would have to be considered to be a bonus and a win for workers who are injured from that date on. But in circumstances where they're set up because the cut-off dates are going to apply, it's probably a fine balance as to whether or not it's an economically viable thing for a worker to receive a lump sum, or whether they wouldn't be better off having the weekly payments and the medical expenses continue. And obviously everyone's individual circumstances will show whether or not it was better for them one way or the other. But I think as a whole, that is certainly a good thing for workers. Under the Workers' Rehabilitation and Compensation Act, the old Act, there were redemptions that were payable to workers to assist them in getting off the system and no longer having to deal with work cover at all. Redemptions are still available under the new system. They are unlikely to be very favourable to workers in circumstances where the future liabilities under a claim are not going to be very big in any event, but there still is the ability to ask for a lump sum to get off the system altogether if a worker is interested in that. Again, you should seek advice about your specific circumstances and what amount of money might be payable to you.